So in case you haven't been following this AJ Scott trial, you're probably wondering what happened. This is one of the craziest stories I've heard. This gentleman, this man, AJ Scott, was a state trooper in South Carolina, and he was traveling at a very high speed, very high rate of speed. He hit some teenagers in the car. 2 of them were okay. The other 2 did not make it. One was ejected from the car and died. The other one died shortly thereafter, right? So now he has a first trial. The first trial, there was actually a mistrial because the defense, according to the state, allegedly withheld some information, right? So the case was delayed. This was over 10 years ago. Case was delayed. During that time, this man, AJ Scott, becomes the mayor.
Stop the cap.
He becomes the mayor, and he's just living his life. He's out there living his life, doing some wild and crazy stuff. While he was mayor, he's trying to get a police officer to be his personal chauffeur, and he clearly had some issues going on. Now we get into a second trial. He's found guilty of the murder of these 2 women, and now he's facing his sentencing. So we're going to hear what the sentencing is from the judge. We're also going to get into some of the impact statements from the victims. And yes, we're also going to hear from AJ himself. Check it out.
Before we get started officially, I just want to go ahead and say I know this is a smaller courtroom. I know it is cramped, and we are trying to work with that the best that we can. Is there anyone in the hallway?
Yes, ma'am.
There are. If you can open the doors so that, and y'all can stand right there, but if you will please open the doors so that it remains open to anyone that's standing in the hallway. We should have door stoppers if you need those.
You see AJ Scott here in the lime green with his attorneys. His attorney was garbage, by the way. Gosh, listening to that guy was brutal. His attorney was trash. The sound low? I got you.
The other 2 door stoppers, so y'all don't have to do the physical door stoppers. Just for those in the hallway, if you will please just make sure that you do not block the entrance and exit. So
sound should be good. Let me know how the sound is.
And if law enforcement tells you to move, please follow their instructions because they're here to maintain safety and welfare of everybody in the courtroom. So please just follow their instructions if you're standing somewhere and they tell you not to. I'm going to move forward, but in just a minute they'll bring you those door stops. All right, cell phones. We had an issue during the trial, so I just want to make sure that if you have your cell phones, please turn them off. And please note that you are not allowed, even at this phase, to use your cell phone in the courtroom. There are 3 entities that are allowed to use a cell phone. If you see someone with a cell phone, please do not take that as permission that you may use your cell phone. So that the deputies know who is authorized to use the cell phone. If you are here with one of the following media outlets, please stand. The Atlanta Journal-Constitution, Court TV.
Shout out to AJC, Court TV.
And WXIA.
We don't care about this. Let's skip it.
Count 3, vehicular homicide. August, and the jury returned its verdict on August 27th. And the verdict was as follows: Count 1, serious injury by vehicle, guilty. Count 2, serious injury by vehicle, guilty. Count 3, vehicular homicide in the 2nd degree, guilty. Count 4, vehicular homicide in the 2nd degree, not guilty. Count 5, speeding, guilty. Count 6, reckless driving, guilty. Pursuant to OCGA 17-10-2A1, I'm doing the pre-sentence hearing today, and the only issue here today is to determine the punishment to be imposed for the charges for which Mr. Scott was found guilty. The range of punishment for each count is as follows. Count 1, serious injury by vehicle. That is set by the Official Code of Georgia 40-6-394B, providing that a person convicted of violating that subsection shall be guilty of a felony and shall be punished by imprisonment for not less than 1 year, nor more than 15 years. Count 2, serious injury by vehicle, is also controlled by that same statute, and a person convicted of violating that subsection shall be guilty of a felony and shall be punished by imprisonment for not less than 1 year, nor more than 15. Vehicular homicide in the 2nd degree, that punishment is under OCGA 17-10-3, providing that a person convicted of that offense shall be guilty of a misdemeanor and punished by a fine not to exceed $1,000 or by confinement for a total term not to exceed 12 months or both. Count 5, speeding, that is also a misdemeanor, punishable by a fine up to $1,000 or confinement for a total term not to exceed 12 months or a combination of fines and incarceration. And count 6, reckless driving, and that sentence is pursuant to OCGA 40-6-390B, providing that a person convicted of such offense shall be guilty of a misdemeanor and punished by a fine not to exceed $1,000 or by confinement up to 12 months or both. I believe that we have some merger issues such that count 6, the reckless driving, would merge into counts 1 and 2. Is that correct?
That's the best way,
Yes, Judge.
All right, so the reckless driving merges into the serious injury by vehicle for purposes of sentencing by operation of law.
Yes.
All right, and then count 5, the speeding, merges into count 3, the vehicular homicide and second degree by operation of law for purposes of sentencing.
Yes.
Yes, Your Honor.
Lock him up.
All right, so today at
Bum.
the sentencing hearing, I'll hear additional evidence and extenuation, mitigation, and/or aggravation of punishment, including a record of any prior criminal conviction, any pleas of guilty or nolo of the accused, or the absence of any prior conviction and pleas. After the verdict was reached, the defense requested a pre-sentence investigation. I issued an order for that to be completed and forwarded it to the Department of Community Supervision. Alexander Holbrooks was assigned to conduct the investigation.
Defendant was the mayor,
for
yes.
DCS. He provided that report to my office and also sent that report prior to today to the state and to the defense. I also was provided the following by Investigator Holbrooks: the defendant's driving history, his GCIC history, the other documents that he had viewed in looking at in reaching his investigation and report, and a table of sentences of current Georgia inmates serving time for serious injury by vehicle on that conviction. I've also received multiple letters on behalf of the state and or the victims and on behalf of Mr. Scott. Those were either sent directly to my office from members of the community and or by the attorneys for the state and or Mr. Pilgrim. Just for purposes of the record, I'm going to go ahead and list the individuals that sent the letters that I am talking about. On behalf of the defendant, I received the following letters: M. Parton, Elmira Barrow, Samantha Thacker, Chad Long, Martha Long, Steve Holcomb, Sharon Sewell, Sherry Taylor, Gunnery Sergeant Lyndon Smith, Ron Mosier, Austin Scott, Kaylee Murray, Amber Turner, Tiffany Robinson, Sean Crooks, Stephen Sapp, Robin Scott, Martha Schiffman, Brandy Scott, Kenneth Fruits, Jeremiah Riley, Robert Angelella, Staff Sergeant Ryan Clay, Major Jackson Smith, Doug Ralston, Dr. Mark Gustafson, John Ivy, Jordan McLean Duke, Tiffany Creel, Gerard McIntyre, Stephen Payne, Joey Wilson, Melverine Willoughby,
Give me 1 second,
Rusty
guys.
Tyler Holcomb, Michael Todd Land, Dr. Dustin Addison, Karen Wild, Patricia Rainey, John Correa, Tommy Rainey, and Robbie Rainey. I received statements also on behalf of the victims and their families and other members of the community: Tracy Tatum, Travis and Deborah Wall, Sarah Finken, Christy Causey, Teresa Clark, Ansley Dutton, Dr. Julie Evenson, Zachary Evenson, Dennis Greenwald, Kelly Nye Hinkson, Courtney B. Hunter, Ashton Klutz Travis, Dee Korth, Brenda Lawson, Shelley Norton, Molly Phillips, Amy Riley, Bailey St. Germain, Holly Stewart, Larry Strickland, and Tori J. I have reviewed all of the letters and all of the documents and the pre-sentence investigation report from Investigator Holbrooks. So at this time, would either party like to make an opening statement?
No, Your Honor.
No, Your Honor, I'm just saying, I'll remarks.
Just for purposes of the record and to make sure that I'm correct in this, there are no pretrial notices or any 1710, 7A or C that apply in this case. Is that correct?
That's correct.
All right, before we start with the evidence from the state and or the defense, I said it earlier, we are pretty packed in here. And we have lots of law enforcement who are present. The law enforcement is here to maintain order and safety. With all of that being said, I cannot imagine the grief, the hurt, or the anger that any of the people in this courtroom may feel. The victim families, certainly I understand that you may be feeling a lot of emotions. I cannot imagine any of that. I understand that the emotions in this case are high. When anyone comes forward to give me a statement. I have asked the deputies to follow a certain order to get to this podium. Anybody giving any oral statement today, if you will direct those to me. And then we can make sure that we don't have any disruptions or any issues in the courtroom today. I have a job to do, so I need to make sure that everything is maintained so that that job can get done. When the witness approaches the stand, if it is
It's
from
tough,
the
man.
victim or anyone the state calls, if you will please come behind the state's table and come to the podium. Anyone from the defense, if you will please come in front of the state's table and reach the podium so that you can be sworn in. I will swear in every one of the witnesses. And before you begin your statement, please state your name clearly and spell it for the court reporter, and then you can go ahead and make your statement. All right, the state can go ahead to present any evidence at this time.
Your Honor, if you would permit, I know you're aware this is a long time coming. We do have several folks that would like to address them.
Yes, ma'am. Anyone you would like that wants to.
I know the
address
mothers are
court,
gonna have to say
They are
something.
all welcome to make their statement.
They've been all over the news.
I would like to start with Kelly Lindsay.
Sad, man.
Good morning. Tap it and let's see if it's on. Yes, it's on. And you can pull it towards you. Good morning. Good morning. All right, Ms. Lindsay, please raise your right hand. Do you swear or affirm the statement you give is the truth and nothing but the truth? You can lower your hand.
My name is Kelly Lindsay, it's Kellie, L-I-N-D-S-E-Y. I am the mother of Kylie Lindsay. First,
Yeah.
I'd like to say thank you for everything you have done. Thank you to the state for the great job they have done. And then I would like to address A.J. Scott and ask him what he was doing 10 years ago today. Because I was burying my daughter today, 10 years ago, because you killed her. With that being said, the lack of remorse, the lack of empathy that we have seen,
Sad.
the
I can't
social media
imagine.
posts that we have been shown from a grandmother blaming myself and Leslie Woods, Isabella's mother, for the death of our own daughters is disgusting. And she should be ashamed.
Dang.
I'm sorry.
It's okay, take your time.
This has been 10 years, it's been a long time coming. AJ abused his power as a trooper as well as when he was mayor. He could have done the right thing when he became mayor and got the power that he got. Instead, he chose to have his police officers pick him up out of different counties because he was too drunk to drive, arguing with people at a bar, unzipping his pants, seeing people in a park that weren't there. The list
Reckless.
goes on and on. Do I feel sorry for some of his family? I do, because I know what they're losing. But they get to see him again, and we don't get to see our daughters. We have to go to their grave and go to a headstone. So they're blessed that they get to still see him. I know a lot of people will, on his side, may discuss how he was a Marine. I thank you for his service. My son was also in the Air Force, and my son had to leave a month after this happened to go serve in Japan and grieve alone, all alone for 5 years. And I just hope that you take that into consideration, and that the court sentences him accordingly to what he has done and what he has put our families through. And yes. Thank you.
Can I say something?
Yes, sir. You'll just raise your right hand. Do you swear or affirm the statement you give is the truth and nothing but the truth? Thank you. You can lower your hand.
Adelson, Lindsay, Allenlensey, that was father. And if I can, I really just have one question for you. Why did you not just pay the speeding ticket, reckless driving, drag us through stink things, we should never seen.
I know it's hard to hear him.
You could have said this wrong twice, but we've had to see this disgusting pictures of our children.
No backdoor this on with it. You smile at me, smirk at me every time y'all two get away with laws things.
Disgusting.
And I don't understand what kind of man does that. So, can you tell me why you didn't pay the $2,000 and let us all go on? We paid you that night to protect us. And instead, you was out there breaking the same laws that you was imposing on the citizens and the taxpayers this community.
It's true.
And felt no remorse, no accountability you shouldn't have brought upon you. You were guilty of nothing. And I just want to understand. So you not feel any guilt for what you did?
Yep, that's him, J Money.
You didn't kill our daughter. You killed our daughter. You may not have been found guilty for our daughter, but you killed our daughter because of your speeding and your choices that night you needed to face the consequences. I don't understand how you looked at the same pictures that we looked at and didn't see your own daughter's face. Because it could have been your daughter too. You should be ashamed right there.
I just hope that this goes to show other troopers, other police. We pay y'all to do a job, that's just protect us and serve us. It's not to hold us accountable, but the same laws that you're out here breaking and think you're above. Because this is what happened.
They're saying that because he was a police officer.
That was my only daughter, and he took something beautiful and wonderful and took her from this world. And they can't get her back. Do I think anyone in prison is going to change any of this? I don't. But I hope y'all find it for me, whatever y'all feel.
Thank you, Mr. and Mrs. Lindsay.
All right, we're gonna skip ahead a little bit to hear from AJ Scott himself. Check
I'll
this
read
out.
his letter, but he was ordered when he originally got bond not to make any statements, not to contact the victim. And my advice, as I would advise all of my clients, the same way, not to do that. Don't reach to the victim, don't reach out to the families, because that can be seen as harassment. It can be seen as intimidation.
Let me see if I can rewind it here. Give me 1 second.
I've asked, the court said, since my client 15 years to serve 36 months in jail. And, Your Honor, that is consistent, that is fair, that is impartial, that is based on facts and evidence. Mr. Chinchilla's life and the loss thereof should not be treated any lighter than the injuries of the young man, nor should their injuries be treated any more than the death of Mr. Chinchilla. Your Honor, I'd like to close with a reading of a letter I have spoken to Mr. Scott.
Here we go. We got a letter from AJ Scott.
10 years that I've known him. He has expressed regret to me. He's expressed regret what happened that night, the decisions he made. He made. But I'll read his letter, but he was ordered when he originally got bond not to make any statements, not to contact the victim. And my advice, as I would advise all of my clients, the same way, not to do that. Don't reach out to the victim, don't reach out to the families, because that can be seen as harassment. It can be seen as intimidation. Ultimately, will result in the revokal of their bond. But I do want to read this letter. Mr. Scott has given to me. He feels that he just can't get through reading this letter, so I'm going to read it for him. From AJ Scott. I'm sorry for my role in this accident, resulting in the death fatality in this car. I really regret that night, every day for the last 10 years, and I will to the day that I die. I mean it when I say I wish it was me that died that evening, not them. I wish they were living their lives that they deserve right now. The world would be a better place if that was the case.
Listen, guys, listen. I believe this. I believe it. It's tough. As hard as it is, I don't think AJ Scott was flying down the road, although as negligent and as reckless as it was, saying, oh, yeah, I hope some teens pull out so I can just. Yes, but this doesn't bring their kids back. And that, as a parent, is what you have to deal with and what you have to look at. Although I don't think this man was speeding down that highway with the intent of killing his kids, he did. Although your sorry is heard, is it appreciated? I doubt it.
I know you as a family have boys in your hearts that will never be healed. I'm sorry for that. My two youngest daughters are now Isabel and college age, and I can't imagine the pain of losing you. I understand your hatred for me, and I hope one day you can find in your hearts to forgive me. But I want you to know that I love each one of you, no matter what. I've been praying for you over the years, and I will continue to do so. I have regrets in my life, but that night is...
Look at this mom shaking his head.
I'm not perfect.
Shaking her head.
Nobody is. However, I have tried the past 10 years to follow God's word and bring good into people's lives by helping those in need and by giving back to my community. I will continue to do so as much as possible for the rest of my life. I wish I had been allowed to reach out to you and to say these things and even more, but I was ordered by the court 10 years ago not to contact you directly or indirectly, and I was following my attorney's advice. I did not make statements to the media or social media. I just want you to know that this isn't because I didn't care, because I did. And I will be glad when the day comes I go to heaven and say all these things I need to say to Callie and Isabella. Thank you for your time and spend, and I love all of you, and God bless. And now I will close with an observation. As I have lived in this life, as we all have lived, we all seek justice. We have different definitions of what justice is. But when it comes to us personally, when it comes to our family, our children, we want mercy. When it comes to our shortcomings and our misgivings, we want mercy. We cry for justice, but in reality, we want mercy. And Your Honor, here I think what I have recommended as a sentence is that justice and mercy.
He should have known better.
Deals both of those areas completely. And I've asked the court to consider that and consider the things that Mr. Scott has done with his life prior to this accident, even after this accident. The things that he's done in service of others, and that should matter. That should matter. If it matters nothing else, it should matter in this case. Your Honor, we ask you, and we'll leave it in your discretion to make a decision. Thank you very much, and I will say on the record, Your Honor, this case is unlike anything I've ever done before. And I want to applaud you for the way you handled this case, and I know this was dropping your last path into the pitch. I want to say thank you for the way you handled this case, all of you who did it, all the extracurricular activities. Thank you for that. Regardless of what happens here today, that's still a chance for you to do a great job handling this, and it wasn't easy. And so I want to say thank you on behalf of the bar, on behalf of my office, and behind this. Thank you.
I think he needed to say that.
Yes, ma'am.
Because he could have said nothing.
Thank you. Judge, as you have heard, the events of September 26, 2015 took the lives of 2 young women,
He did.
destroyed the lives of 2 young men and countless others,
He did.
and for what? 90 and 55, because he could. Dylan Wall has lived for 10 years being told that he was responsible for this collision. For 10 years, these victims have been vilified based on pure speculation. Speculation based on maybes, possibilities, what ifs, might haves. Maybe Dylan was intoxicated. Kylie might have been sitting in the front of the vehicle. It's possible this or that. The jury has heard all the evidence, and none of these things were proven. Their verdict speaks the truth, that if the defendant had been driving the speed limit that night, this collision wouldn't have happened.
Yep.
The defense has provided the court with prior sentences for serious injury or vehicular homicide cases, most of which include DUI, and have asked you to treat the defendant differently in some respects because he was not under the influence. We would argue to the contrary. The most recent Georgia Department of Public Safety Policy Manual mission statement reads, the mission of the Georgia Department of Public Safety is to work cooperatively with all levels of government to provide a safe environment for residents and visitors to our state. In all endeavors, DPS personnel will provide the highest level of customer service while remaining committed to following our core beliefs of trust, fortitude, compassion, and professionalism. I can't imagine that the core beliefs of the State Patrol were that much different in 2015, when the defendant ignored the posted speed limit of 55 and 45-mile-per-hour warning signs of the upcoming intersection on a wet road to do what? Catch up on reports, retrieve his radio? Coincidentally, Judge, on the way here today, I was listening to the morning news, and there was a report there that was put out by AAA based on the NHTSA study that said that drunk driving is responsible for 30% of traffic fatalities, and speeding is responsible for 29, confirming just what we already know, that speed kills.
Mm-hmm.
So yes, the defendant should be held to a higher standard than even the fool who drives under the influence, because he owed a duty to the citizens on his watch, the duty to honor the badge that he wore, the duty to uphold the law and not violate it. He failed at all of these the night he ended the lives of Isabella Chinchilla and Kylie Lindsay, and altered forever those of Ben Finken and Dylan Ball. During his interview for the pretrial investigation report, the defendant stated that he had wished it had been him and has wanted to apologize to the victims and their families for the past 10 years. These sentiments seem hollow in light of the fact that while the jury was deliberating during the first trial, a handwritten note was sent to the prosecutors that said the defendant would plead guilty in exchange for a dismissal of the remaining charges.
Wow.
And in addition, the note demanded an apology from the district attorney's office and an admission that the defendant was not responsible for the injuries and the deaths be sent to all local news agencies. A stunning lack of remorse. This was a senseless and avoidable tragedy, brought on by a member of the law enforcement community in complete disregard for the tried and true protect and serve. Your Honor, our recommendation is as follows. As to count 1, serious injury, 15 years to serve in custody. As to count 2, serious injury, 15 years to serve 5 years in custody to run consecutive to count 1. Count 3, vehicular homicide, 12 months to serve consecutive to count 1. Count 5, speeding, merges, as you know, with count 4, Judge. Count 6 merges with count 1, for a total recommendation of 30 years to serve 20 years in custody. Thank you.
I think that's fair and reasonable. I don't want to hear one concurrent. Get this man up out of here. All right, let's skip ahead to what the judge has to say.
Years ago, I was not even a judge. It has been a long time to get to this phase in this trial.
Mm-hmm.
When I scheduled this sentencing hearing, I had no idea it was the 10-year anniversary of the funerals for Ms. Chinchilla and Ms. Lindsay. And so to the family, I'm extremely sorry that I did that if it caused you any further pain.
What a nice judge to
I really
point
did
that
not
out.
know that this was the anniversary of the actual funerals. So please accept my apologies.
That's why.
I think everybody agrees that 10 years was a long time to get here. And there were multiple families that were forever impacted on the night of September 26, 2015. I agree with what Mr. Pilgrim said. There are only losers here. I have never lost what the people in this courtroom lost. And I say that for all families involved. But I've never lost a child.
And I pray no one else
the
does.
families and friends of Ms. Chinchilla and Ms. Lindsay, I'm very sorry. Some scars never heal. And I cannot begin to imagine your emotions and your pain and your grief. I'm sincerely sorry for the loss of your girls. To Mr. Wall and Mr. Finken, I'm sorry for your injuries that you sustained. I want all of the victims to know nothing I say in this courtroom today is going to change the way that you feel. It's going to change the way that your hearts hurt when you grieve your loved one or you consider what happened that night. Nothing is going to take away the memory of that night and all of the lasting impact for anybody who experienced it. Mr. Scott had no intent to harm anyone, and the evidence was what the evidence is. And Mr. Scott was charged with crimes in the state of Georgia that did not require any malicious intent. But those actions do have consequences, and Georgia law prescribes what I'm supposed to follow in sentencing. The jury was responsible for finding the truth of the case, as they found the truth of the case to be. I'm not here to retry anything, and I'm not the trier of fact. My job is to now sentence accordingly pursuant to the law, and I'm going to follow the same instructions that I gave the jury, which is to not be swayed by sympathy or prejudice or public opinion in rendering my sentence. There's been a lot said today in the courtroom about being a Christian. I am a Christian. I'm not ashamed to admit that. But I am not here to judge anybody in a religious sense. That is not my job. My job is to sentence accordingly according to the laws of the state of Georgia, on the charges that the jury found Mr. Scott guilty of.
Yep.
And so, after considering all of the evidence presented to me in this pre-sentence hearing, along with all of the other evidence that I stated, and I did not include at the outset that I had reviewed the sentences in Carroll County that Mr. Pilgrim mentioned. I have reviewed those as well, so I just want to make sure that I note that. But also considering the argument and everything that has been presented, I am going to follow the recommendation of the Department of Community Supervision. Their job is to look into this, do a thorough investigation, and to report to me as the supervisors of those on probation what the appropriate sentence should be. And it was a very, very thorough investigation presented by Officer Holbrooks with all the attached documents. And I believe that in looking at that, as well as looking at all of the letters and things that I was provided, and the sentence printout, I'll just pull it up, that was given to me by DCS for individuals serving on the same or similar charges, that what DCS has recommended is in line with those. Just to let you all know further, I reviewed every single one of these online at the Department of Corrections. I looked them up. I considered all of the charges that were there. I reviewed any past prior history that is on each one of those individuals, and some of them have longer sentences, some of them have a little bit shorter, and there are lots of things that go into play there. Every case is different, but I do find that the recommendation from Officer Holbrooks and the Department of Community Supervision is appropriate and just. So I will sentence as follows. Count 1, 10 years to serve 5. Count 2, 10 serve 5 consecutive to count 1. Count 3, 12 months to run concurrent with counts 1 and 2. Count 5 merges by operation of law with count 3. Count 6 merges by operation of law with counts 1 and 2. That is a total of 20 years to serve 10 years.
20 to serve 10.
There are also the general conditions of probation that will apply. In addition to the standard or general conditions of probation, I'm also going to impose special conditions of probation, which means that if any of these special conditions are violated, the entire balance of probation can be revoked, even if the violation does not constitute a new criminal offense. Was there any restitution? I know there was some pre-trial stipulations on things that could not be considered, but is there any restitution that anyone is aware of?
Judge, I don't believe so.
Okay. All right. Then the special conditions will be number 2, report to probation. Number 4, Probation Management Act.
So he's got 10 years to serve right now.
Judge, I apologize.
That's okay. Yes, you can.
And hardly any time served. How are y'all feeling about this? We'll skip ahead. I know the family's not happy about this. 10 years to serve. He killed 2 people.
Council, so that it is cleaner and it does not split the sentence and have any issues at the Department of Corrections, I'm going to amend that sentence just a bit.
How would y'all feel?
It will still be a total of 20 to serve 10, but count 1 is 10 years to serve. Count 2 is 10 years to be served on probation consecutive to count 1, and the rest will remain the same. And then we don't have the splitting between serving and probation, where it might
Not
be
long
something.
enough.
Y'all agree on that? I know you don't agree on the sentence, but do you agree that that is cleaner for purposes of Department of
No
Justice?
objection to the consideration.
Okay. All right, so let me go back to the special conditions. 2, report to probation. 4, Probation Management Act. 11, drug testing and admissibility. 'I believe from everything that was said here today, the victims and their families want no contact. Is that correct?
Correct.
All right. Okay, and 12, no contact with the surviving victims or any contact with any victims' family members.
Yeah, that shouldn't be a problem.
15, records release. 19, curfew. That just means that probation can put a curfew in place if it needs one at some point in time in the future. 25, provide a DNA sample. 21, surrender your driver's license. Community service, 60 days of community service. And 32, no drugs or alcohol during the term of the sentence.
And he does have issues with alcohol too. So he's going to be
Any
nice and
questions
sober.
or issues on behalf of the state on those conditions?
No, Your Honor.
No, Your Honor, only question Your Honor I had asked for possible first offender is eligible. You have his criminal history.
Dang, don't say it like that. Your child's life is worth 60 months. Ah.
No, sir, I'm not approving first offender.
Thank you.
All right, Mr. Scott, I'm going to go over with you your appellate rights. You have a right to
Yeah,
seek
we don't care about his rights. Oh my gosh, 10 years? 10 years? Again, the defense, you got to give it up to his defense team. They clearly did a good job of showing how it wasn't completely his fault, and possibly the way the kids took that turn, the timing they took that turn had to factor in, because otherwise, I mean, he should be in jail for the rest of his life. Very sad to see. I can imagine how the family is feeling in this. And I will be covering any post-trial or post-sentencing coverage that we find on this in a later video. So make sure y'all stick around for that. Let me know what you think in the comments in the chat.